Moving on, I'd mentioned standards for produce safety. This is another area of the law which is rather significant. The FSMA is thrusting FDA into agriculture, which is an area that FDA has experience with, but traditionally has been governed by either states or USDA. This reaches into produce that's grown on farms, and traditionally farms have been, I wouldn't say off limits, but they tend not to be focused on by FDA unless there's some kind of a foodborne outbreak, and it sort of drives FDA through the investigation back to a farm. Here, FSMA is instructing FDA to work with USDA and with state departments of agriculture and, interestingly, Department of Homeland Security to establish performance standards to produce and harvest raw agricultural commodities or fresh fruits and vegetables. So here, FDA is being driven essentially into the development of performance standards, which would govern fresh produce, both fruits and vegetables. FDA is required to prioritize its work based upon the commodities that have been associated with foodborne illnesses in the past. So that they should take into consideration outbreaks and prioritize their efforts here on those foods where there have been some historical problems. These performance standards are to be issued in the form of a guidance document or I think really a regulation. But they're not permitted to be duplicative of USDA documents. So if USDA already has guidance out on standards, then they have to work with USDA in order to come up with a single guidance. They can't duplicate the efforts here. And so that presumably that would also be read to include preventing any conflict in documents among these agencies, which is often a problem in the industries where you've got multiple agencies regulating the same industry. The specific focus of the regulations are to be for a purpose of minimizing risk of serious adverse health consequences or death. That means the regulations are supposed to be focusing on big stuff and not small stuff. FDA should be focusing its standards on the kinds of things that, if the standard is not met, it produces a serious risk of a health consequence, a serious adverse health consequence or death concern here. So now, one thing that is significant is FDA gets to determine whether the regulations will achieve the end of minimizing the risks. And FDA has to work with USDA, states, and DHS, but FDA is essentially given the power to decide whether they think they've gotten there or not. So they're given a pretty important seat at the table in this regard. FDA will read the addition of Homeland Security in this provision to add reach to food security in the agriculture industry. So that's something that people should be in the fresh produce and vegetable industry should be conscious of the fact that FDA will likely be coming up with food security regulations as a part of the performance standards under this reg. So that's a pretty significant increase in FDA power. And now they're doing this along with about 1,000 other things, so it's going to take them time, but it's not going to take them forever. They are going to get to these. And FDA's already written so many guidance documents that are in the area, it shouldn't take them as long to deal with security issues as it does perhaps some of these others where they have to actually create standards. Continuing on with these standards for produce safety, you'll see that there are some exemptions, specifically facilities that are subject to the HARP-C requirements we just talked about. They're exempt from standards for produce safety. So basically, you can think that every food facility or farm will be governed by one of these new regimes, or HACCP, of course. HACCP is one of the other options. This burden, though, that's going to be added, we think should be of concern to family-owned farms. Now, what FDA did, or what Congress did, was they created a direct marketing from farm to consumer exemption. So this would be where you drive down the road and you stop in at a farmer's market and there's a farmer's stand, a fruit stand, or a vegetable stand right on the farm, and that produce is picked on the farm where the stand's located. Then presumably there would be an exemption from these standards requirements as granted by Congress. So there's that, and then a direct marketing from farm to restaurant or retail food establishments, which are also exempt. You'll see that there's a 27-mile radius restriction, which is sort of arbitrary, but nonetheless, it's in the statute. But these were the exemptions to these standards for produce safety. I think rather unrealistically, FSMA instructs FDA to issue a notice of proposed rulemaking on these standards by January 4th of next year. That's extremely fast. FDA would have to finalize the regs within a year after they close the comment period. So, in other words, there's a proposed rule requirement that's in the statute that's within a year to propose a rule, and then they've got a year after the comment period closes to finalize the reg. That's a lot, and we would expect there to be a pretty vigorous comment period on this because of the fact that it's such an increase in FDA's jurisdiction. Regulations here have to cover growing, harvesting, sorting, packing, storage operations, soil, hygiene, food packaging, and everything you can basically think of that would happen on a farm. So it's a pretty extensive regulatory power. You'll see that there's some additional time that's allotted for these facilities to comply, small businesses versus very small businesses, some extra time that's granted, and that's Congress listening to the trade, who is saying that it's one thing for a large company to put some of these systems in place. It's quite another thing for the expense, related to expense for smaller businesses to do so, and Congress heard that, and so they added these exemptions.